turn it back on again. But I think that finally did the trick.
You still
Oh.
use Virginia still uses dial-up modems?
Evidently. And we still don't have our new cable line yet. They're supposed to come either this week or next week and actually uh, lay a new underground line for us. So hopefully that's going to put an end to all these problems. So you guys know, Bill's been texting me or direct messaging me that I should just move back to Northern Virginia, but that's not going to happen. Eventually, we will get our technology issue here straightened out. So I apologize for the technical difficulties. So we were talking about we hadn't gotten very far. So let's just start a little bit
Oh
over.
yeah, we covered almost the whole thing while you were gone.
Oh yeah, we covered the whole thing. I know you guys solved all the problems while I was shut down. So we were discussing, and King, you were making an interesting point, and then I lost you about the way the document is put together.
And
That
then he did a whole Monty Python skit, and everybody laughed.
really, I missed it. Damn, I'll have to go
It
back and
it
listen to that.
it
Except it
it
says
it,
it's
it has a
unavailable.
it has a very wink wink nudge nudge say no more feel to it. The
Mm,
way Smith is beginning his dialogue with Judge Chutkin.
yeah,
He leaves it to her when he gets to drop his bombshell or
right,
his atom bomb
right.
filing, which is
On the
which is
on the country, yeah.
yeah, which basically is going to be the way he describes it, his case, including all the evidence against Trump.
Right. And you were linking that to Monty Python how?
Wink, wink, nudge, nudge,
Oh,
say no
wink,
more.
say no more.
Uh,
Yes, right.
Judge,
I got you. Yep.
Judge, you tell me when I can do this, but wink, wink, because I can't. But
Right.
it's ready to go.
Right.
Now let me add a little context to this. If you're a subscriber to my X account, you'll have seen that I wrote this last night. But since there's only 197 subscribers, I'm going to guess that pretty much nobody has seen it.
Right.
This is the same guy who indicted the case on August 1st, 2023. On August 10th, 2023, he proposed jury selection on December 11th and the trial to begin on January 2nd with 10 filing and hearing dates in between. And now on the superseding indictment, he says, I've got no dates to offer you. Just let me file this brief.
Right. Right. So it's like a complete sea change from what he was trying to do. Now,
No, wait, wait.
Well, hold on. Yeah,
This
but
that's
what else
not
has
true.
changed? But what
What?
else has changed? He can't get it tried before the election. So now he
Yeah,
right.
doesn't care.
Right.
one getting it tried and convicted before the election would be his option 1A. But 1B
Right.
is where he's going. And 1B is, well, let me show the country in advance of the election everything I've got to nail Trump with. That's what
Right.
he's up to. And that's going to include grand jury stuff, uh, testimony, and exhibits that Trump will never have seen before, won't have a chance to cross examine. It's all going to be a one sided, star chamber like proceeding that'll be there for sitting there in the courthouse record for a month or two in advance of the election. He's outlined probably one of the more unfair things I've ever seen in a criminal case.
Right. And I'm wondering why is he, well, I know why, but he should not really be proposing to do this as a public filing, right? Then the defense makes that point in their part of the submission. They say this could all be done by private exchange, letter or whatever, between the parties. And, usually discovery is, and this kind of, commentary on evidence, the government wants to use certain things, is usually done between the two parties unless you have specific motions that you want the judge to rule on. Now, here the prosecutor can certainly say, well, the Chutkin has to rule on whether this stuff is immune or not. So, what did you guys Think of that. Ship as a prosecutor, former prosecutor. Would you in
Well,
California
this is
practice there normally have this be public, or would it be just between the parties? This kind of thing.
well, this well, I mean, let's analogize it to a dispute over the scope of testimony that might otherwise be covered by the attorney-client privilege.
Right.
Does that get trotted out for the public on the public record for the debate to take place over what is confidential information? Now, it's not strictly analogous here because that is confidential, and the presidential immunity is not necessarily based on confidentiality. Um, but I mean, you go back to the Supreme Court opinion; it talks about the presidential immunity is based upon separation of powers issue, not a confidentiality issue. Um, but to me, it's I don't know that really struck me as the issue. Is it's just this is Smith wanting to avoid the mini trial, which encompasses cross examination and contrary evidence. This is him wanting his cake and eating it too. He just wants to pour it all in to the public record. You know, his this is going to be his indictment on steroids. It's going to be the allegations of the indictment combined with, potentially transcripts of testimony before the grand jury,
Yeah, but
documentary evidence,
he can't
and it's
file that
and it's
though, right? He can't file grand
sure
jury.
he can. If she tells him she can't, he can.
Yeah, but he
He
doesn't
he
say anything in this
he
status report about that.
he could put it in the form of a summary, but he fully he fully wants to make a proffer of all of the evidence he's got to support his case.
Right,
Is the
and
way
that's what I'm
way
And
I
saying.
he's
I'm
and it's
sort
going
of
to be
betwixt and between because if you file a motion in limine as the defense lawyer and say this witness should not be allowed to testify about the following things, blah 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 blah, and you lay out what all it is, and you want the exhibit struck that you know the government's going to use, you do that in a public filing. You don't, that doesn't happen behind closed doors.
no,
So
right. But
but what's happening
yeah, but the
here is without the defense having the opportunity to object, file a motion in limine, obtain Brady materials, cross-examine the witnesses that are spelled out, their testimony is spelled out in this proffer. Uh, it's a one-sided Star Chamber-like proceeding. If the judge agrees with Smith, this is how this should go.
well, okay,
now
but
now let me ask you
not
this, Leslie. Let
exactly.
me ask you this.
The government is
Let me pose a
I'm
question.
playing devil's advocate here, but the government is proposing to file all of this stuff. Like we talked about last week, we said we would demand for the government to identify which exhibits, what's your testimony going to be, what's your allegations exactly, and then the defense has a chance to respond to that. If she orders the government to file that next week because they say they're ready to go, even if she gives the defense a month to file a counter pleading, that can all be done in advance of the election, and it doesn't preclude a hearing either, right? Smith, he's talking big in his thing here saying, well, he thinks it'll be perfectly obvious from what he's filing that it's not immune, but it probably won't be, right? We'll probably be jumping up and down like we have been saying, well, two-thirds of this is clearly immune.
What happens across is
Yeah,
right to confront witnesses and right to cross-examine.
Yeah, but we're not at trial yet though.
It
well,
it's
but
pretty
but
much a
but the
trial as
Supreme Court
far as
talked
the
about
voting public is concerned.
Yeah, well, that's not in the Sixth Amendment, though, is it? You get to cross-examine because you're standing for election. So I
You
just
don't think any of the prospective jurors will be reading about or hearing
no.
about all
Okay,
this?
but yes, but I think that's a different question. Whether it's interfering with the election, unduly prejudicing the former president in the at the ballot box is a different question from whether it's prejudicing him in his case, which is all Judge Chutkin is supposed to be worried about, I think. I don't know. I just go back and forth because I have a strong feeling that as a defense lawyer, I would be saying none of this needs to be on the public record, right? It needs to be that they give us their submission in private and then we determine what we think about it. And then we might be able to agree on things. And then let us bring to you, Judge, just the stuff we don't agree on. right? But at the same time, I just think, the last trial that I tried in Maryland in federal court, I filed 9 motions in limine and asked, all kinds of different theories and arguments for why the government's evidence shouldn't come in. And with the exception of sealed grand jury transcripts, that just all goes on the record. It just does. So I'm not sure. Just looking at it from a legal point of view, forgetting for a moment about the election. Ship, what do you
Yeah,
think?
but I think this is different. Are you not hearing me?
Yeah, I can hear you now.
Is okay. All right. I want consider this. How many lawyers do you think are working with Smith right now? 8, 10,
Yeah,
12?
right. A dozen, probably all counted up. Yeah.
And they've had 2 months at least since the immunity decision came down. This thing that Smith proposes could be 4,000 pages
Oh, I
long.
agree. It's a totally novel, one-off pleading, never been filed in the history of the U.S. courts
Exactly.
before, kind of thing. Yeah.
And they have been working on it every
Right.
day because this was always what they were going to do. Because they don't. This is their this is their election interference. This is the trial that they didn't get to have. Now they don't want to subject themselves to a counter narrative. They lay something that's 2, 3, 4,000 pages out into the record. There is no conceivable way the defense can digest it and respond to it, even before the election.
Right. That may be as a practical matter. Right. But you and I both know that happens to defense lawyers all the time. Right. The government's been investigating your
No, no,
case
no. There's
for,
not. There's not an election.
well,
There's not an election all the
but I'm
time.
saying you,
This is an overt. This is an overt, un disguised, non-concealed
right.
effort to drop a big old
Oh,
bomb in the
I'm
Or
not
middle
the,
of the election
disagreeing with
campaign.
you. I'm saying, but as a question of going forward with the case, do you think Judge Chutkin's going to take that into account? And the defense doesn't make that point in their part of it. They make the point I'm making that this should be between us chickens, right? Shouldn't be out on the public record, basically. And they don't strongly make that argument. They just sort of assert that. They don't say because it's interfering
Well,
with the election.
I don't think they had it before in advance. I don't think they fully appreciated what Smith was up to with his wink, wink, nudge, nudge, say no more tactic. Uh,
I agree. I think they both expect. I think the Trump team expected to talk to Smith about a schedule. Smith's schedule was going to be faster than what they wanted,
Right.
but they were both going to talk about a schedule. And instead, Smith has laid his cards on the table and said, "I don't give a shit about a schedule. I'm going to dump all of this shit into the public record, and that's what I'm going to propose we do because maybe the judge will let me do it."
Well, that's why I started out by saying, probably in the last space, is that the document reads like it's two completely different people doing this, right? Like they didn't talk before, which isn't the way this is supposed to go, right? It's the document.
Well, I think what I would have guessed just from based on what I read and kind of intuiting into the mindset of both sides, I'm going to guess that whoever did this for Smith or Smith himself said this is what we're going to do. This is what we're going to say. You want to say something different, go ahead. But if you don't agree with us, that's fine. This is what we're going to propose. We don't have to agree to anything.
Right. Okay. But the point you were just making is that you didn't think the defense had seen what the government was proposing. I don't understand how that could be, right? Because the way these joint status
Well, no,
reports
no.
work is you're supposed to exchange or you're supposed to discuss your opinion,
Oh, no,
your
no.
positions for one thing.
I understand, but no, I think Smith told them what they're going to do.
Right.
But I think that was the first moment when they realized what he was suggesting. I don't think they knew about this a month ago. I bet this conversation took place on Wednesday or
Oh,
Thursday.
yes, I agree with that because Smith's been he says he's been trying to make up his mind all this time, when in reality he's been preparing this megaton, bomb that he wants to
Yeah,
set off.
what
Right.
I would suggest if I was Trump is I would say, look, he's now pled his superseding indictment. The proper process should be we object to the superseding indictment where we think is objectionable, and then Smith defends himself. Because if we say it's all fine, then what's the point of Smith's filing?
Trump also argues the first thing the judge has to consider, even in advance of immunity, is uh, Smith's appointment.
Right. They throw up a bunch of things saying, really, we're not ready to do what Smith wants to do because they want her to consider Smith's appointment. They want her to finish resolving who's part of the prosecution team and who isn't, because that helps determine the scope of the Brady. There's Brady issues outstanding. They basically say, we're not even close to getting ready to do this immunity stuff now. And they lay, for those of you who haven't read the document, which I assume is most people listening, they lay out like an actual schedule with dates. We want to do these things on these days. Whereas the government's part of the document basically just says it's a narrative. It doesn't really have a schedule. And it says that, they want to tell the court and the other side how they're oh so right about that Trump doesn't have immunity, and then let the defense counteract that if they can. So it's sort of what we talked about last week, which is how is the defense supposed to challenge the immunity without knowing what the evidence is? But at the same time, it's kind of what you were proposing, Chip, which is the government's trying to put the burden on the defense.
The the government also points out that Judge Chutkan has already announced that she wants to do the immunity issue first. So,
Right. She did
and
say that. Right. Yeah. She thinks
and
she's picking up
if
where the
she
Supreme Court
sticks
left off. Yep.
if she sticks to that, this is how the government wants to proceed, and I think it raises serious legal issues in addition to election interference, because if it's the kind of approach that is not only going to get the attention of the entire U.S. voting public and all the media, for sure, uh, but Washington D.C. in particular,
Yeah.
how is
I
it
agree.
not going to taint a jury?
Right. I agree. So, but what I want to come back to the way the documents put together, because I don't think people, unless they're lawyers, know how this works. So, for a joint status report, what you're supposed to do is you're supposed to confer together, the lawyers for each side, on whatever the topic is that the judge wants a status report on. And you're supposed to try to come to an agreement if you can on stuff. If you can't, that's fine, especially in the criminal side. And the civil side, the judges expect lawyers to be able to agree on more. But on the criminal side, often you cannot, because the defense is obligated to raise things and object to things, um, because of the defendant's constitutional rights. So there's less agreement usually on the criminal side. But usually there's at least a few things you can agree on. But what you do is, after you figure out what you can and can't agree on, is then usually the government wants to take the lead on drafting the report, and each side lays out their positions for the judge. This is what we agree on, this is what we don't agree on, and these are the things we need you to rule on. You don't usually see as much disagreement as you do in this report, but I wasn't shocked and amazed to see as much disagreement here. But what struck me about the document is that it's like the government wrote the first few pages and then the defense wrote the rest of it. And then at the end, there's just the signatures. And so the last line is basically the defense asking the judge to let me see if I get the language here, adopt Trump's schedule and reject the special counsel's proposal. And then they all sign. And it's it's a strange kind of joint pleading, I think. Normally, you would have another section at the end after the defense's position where you would again kind of jointly be speaking to the court and saying something. Um, but here it's almost like Jack Smith's people have signed, to the defense proposal, which clearly they don't. Go ahead, Chip.
Read that to me again. I don't have it in front of me.
The very
Read that
last,
again. I don't have it in front
yeah,
of me.
the very last sentence says the court should adopt President Trump's schedule and reject the special counsel's proposal. And then the very next line is respectfully submitted and all of their signatures. Like, this pleading looks very strange to me.
Yeah, that sounds like there was two sections, and then somebody slapped all the signatures on the bottom when Smith's signature should have been up underneath his submission.
Right. Or
And
there, yes,
10,
or there should be another section here.
10:51,
Yeah,
yeah,
right.
10:51 p.m. on a Friday night sometimes explains
Well,
that.
that's true. That's
Nobody
true.
noticed that it
It
doesn't read
doesn't
very
read
well.
correctly, which goes to your point, which is they're doing this obviously at the last minute, right? It makes me wonder, did
Right.
they exchange their, because sometimes you'll exchange your language with the government, right? Steve
Well,
having
you
a
think
sneezing
now
fit back here. God
let's
bless you.
let's back up a second.
Yeah.
Back up a second. If it's signed at 10:50, or if it's filed at 10:51 on a Friday night, it would not shock me that the last conversation ended at 10:45 on a Friday night.
Right. Yeah.
So they were talking right up to the end, because if the conversation had taken place on Thursday or Friday, it wouldn't have been a 10:51 filing.
Right. I agree with you. So did they sandbag the defense and just, you know, not tell them we're not going to propose a schedule and we're going to propose this, megathon
Uh,
pleading instead?
I suspect they did, because think about it in this terms. Do you think that maybe they're a little butthurt over the fact that their entire case got put into the deep freeze back in December, and Trump ended up winning?
Yeah. Yeah.
There are some people in that office that are irate over the position they find
Well,
themselves
I
in.
suppose, but you're supposed to have enough professionalism to be able to talk to the lawyers on the other side
What
and file a joint
what
status
what
report.
what part of their history suggests that
I
that's true?
know. Well,
Uh,
but my
uh,
point is that their document is showing it, right? Their document is showing that they're not acting professionally.
my
Their proposal shows
yeah.
that.
What I'm stronger than Ship. This thing blares out in blinking neon lights. This is a sandbag.
Mm,
This is it. That's what this is. That's what they did to the defense.
right. So you think they just said, we're going to write what we're going to write. Send us, because one person has to file this, right? You defense, send us what you want to say. We'll add it to the end of ours and we'll slap the signatures on the end. We'll send that to the judge.
Exactly.
Yeah, that may be very well be what happened.
Yeah, if you pull up Pacer, it'll tell you who filed it.
Yeah. Well, I'm pretty sure it was filed by Smith's team. It was on the notice I got. I think it was Molly, whatever her name is, was the filer. Molly Gaston.
Gaston.
Yeah, she was the filer, I believe. So she's on the special counsel's team.
Because
Yeah,
if Trump's team had
All this language.
all of this
Yeah.
language ahead of time, their immediate reaction was, "You can't do that. It has to be a joint filing. We have to get together and agree on the like the parameters of of
Right.
of what goes in, and we get to rebut at the same time what you're saying. You can't put your whole side in like that unopposed. That's just unfair."
Right. And there isn't a lot of objection along that line, right? In the defense's position, there's no like counterpoint to the government. So, right,
Correct.
as we're talking through, it is kind of like this got cobbled together at the end without them
yeah.
really communicating.
Well, let me ask you, Leslie, if that just hypothetically, you're a defense lawyer and you're on the receiving end of that proposal by the government with 24 hours to put together your joint status filing, don't you mention an
Well,
objection to that
that's what I'm
proposal?
saying. How late did they get it? Because
Yeah.
the defense,
Exactly.
yeah,
But
yeah,
That's evidence
I
of a
think we sniffed
sandbag.
it
That's
out.
evidence of a sandbag.
Yeah, we sniffed it
yeah,
out. The fact that there was no time for the Trump defense even to cobble together a response about what a ridiculous proposal and include it suggests that they were not. In other words, the Trump team probably worked on their.
yes,
Okay, so
yes.
let
Because
they
these
worked on
documents,
their
this reads
schedule,
like this
and
is
then
two entirely different documents, sewed
right,
together. Yeah.
and they expected to get a similar schedule from Smith, which would have been greatly accelerated, and then they could have either proposed, alternative dates on a variety of things, one faster than the other, and then the judge would have compromised or whatever, blah blah blah.
Right.
But at the 11th hour, probably getting nothing from Smith's office, getting no proposed schedule. They're finally calling, what do you got? What's your schedule? What's your schedule? And Smith's office says, we're not submitting one.
Right.
And it's and then it's the 11th hour. It's the 11th hour and 59th minute, and the status. Now, what I might have done in that circumstance, I might have filed a separate
Exactly. I
suit
wouldn't have filed
and just
this
said,
only.
yeah,
Not, no way.
I would have said, I would have called out Smith publicly if in fact this was a kind of like a 11th hour sandbag. I'd have called out Smith publicly. That's me. I'm not shy about throwing hammers.
Right. I wouldn't have been shy about doing that either. Now, the last page, page 9, has two paragraphs where they're making some of the arguments that King is making. So I don't think they literally got it at the last minute, but they couldn't have got it very long before the filing had to take place because it's very perfunctory what they're saying. One paragraph where they're saying we haven't, they don't cite any authority for that. We have a right to challenge it now as the defense. They don't have any right to preemptively challenge whatever submissions we might make. Um, it's reads, the language is fine, but it's not very strong. It's not what you would put together if you'd had a day to think about what the special counsel is proposing. I don't think. These lawyers are better than this in other circumstances, right? There are other filings in their other cases, like the one we talked about last time in New York, where they laid out all the problems with the immunity issues for the federal court trying to get um, the removal in New York again. That pleading reads very well. This one does not, and it should read better than this. I'm not faulting Trump's lawyers. I'm saying I think that they didn't have a chance to fully think through their arguments before they had to file this.
I think we're probably all pretty much agreement
Yeah.
on that point.
Yeah. So it's like in there, but it's not strong. And as a tactician, you have to decide that, right? Do you say nothing and say, I haven't had enough time to respond to this, I'm going to file a supplement tomorrow? Or do you just do the best that you can with the half hour that you've got before you have to file? So, I can't imagine this is what they would have filed if they'd really had it for any length of time. But I'm with you, Ship. I would have filed something else, or I would have filed nothing in this document on it and said that they gave us too late to respond to that. We're going to respond tomorrow because it's after 11 o'clock already. So, but back to King's point, I don't think, let me search the document. I don't think anywhere in here do they complain that it's an interference with the election, what the special counsel is proposing. They don't.
No, no, they don't.
I suspect they want to. I just suspect they want to avoid saying that overtly because that's just going to draw her response. I'm not concerned about the election because she's already said
She
that.
Right.
said that, but now
Yeah.
within 2 months of election, uh, the jury is going to be voting. She has
Right.
to consider that. She has to consider that.
Well, Ship, what do you think? I mean, she should, but does she have to?
I think she has to.
Oh, hang on. You know what? I got. I need to drop off here for 5 minutes to get something. Well, I got to get something filed
Okay.
I forgot about. I got a midnight flight, so let me get that done.
Okay.
Let me get. Well, and somebody just reminded me. Have I proofread it yet
Oh,
to approve it?
yeah.
So I need to
Come
proofread
back
real
to you.
quick.
All right. Well, King and
All
I
right,
can talk
I'll
for a
come
few
back.
minutes. Jump back on when you can.
All right,
Sure.
I'll be back.
Uh,
See, you guys, this is how lawyers are. We're always working against that midnight deadline. And it didn't used to be that way. It used to be you had to file by 5, and if you didn't get it there, you were screwed, unless the court had an after hours Dropbox. Um, so, all right, King. So they do address some of the points we were talking about last week, right?
yes. You have a major issue as to whether Trump lawyers are going to get Judge Chutkan to change her mind on what she does first. They make a strong case that she can't do anything until she decides their motion to throw it all out because uh, Smith was unlawfully appointed
Right.
and, and unlawfully funded.
Right. And they say a couple of times, basically, if the court doesn't grant our motion on that, which it should, then the court should do blah, blah, blah. And, normally you don't put that kind of thing in your motion. You don't tell the judge, you should grant it. Really, you should. Really, 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 you ought to. But I laughed really hard at this because it's so clear that they're really trying to tell her, judge, do the right thing, make the right decision on that, and that solves all your other problems. But I don't think she's going to agree. We've talked about this twice already, but we don't think she's going to agree with the Florida judge, Judge Cannon, that Smith's not properly appointed, and she kind of can't based on what the D.C. Circuit's precedents are. But the defense is
Has
clearly
the D
pushing that. Yeah.
did the D.C. Circuit actually decide the issue of um, that that was addressed in the Florida case? The appointments clause as it applied to uh, the special counsel under the DOJ regulations.
Yes, not this special counsel. I don't think it is. I think it was Mueller. But
Yeah.
they looked
Well,
at the argument that Judge Cannon is relying on.
which case was that?
If I remember it right, it's the case with those Russian companies.
Okay, I was not aware that got to the D.C. Circuit.
Yeah, because the circuit, I don't think there's two circuit precedents, the names of which are escaping me, but I don't think either of them are Trump cases. I think they are Smith cases. I think they predate Smith.
That'd be the Mueller charges against the Russian companies for the bots and
Right.
the
Yeah,
yeah.
right, for the Facebook ads and all of that nonsense. So, yeah. So the holding is on point. It's in terms of the regulation, the legal argument is the same, I believe. So I think she is bound by that.
Yeah, if she's bound by that, that's a quick decision. Uh,
Right. So, okay, so that's how she's going to come out on that. And, the Trump people are still pushing it hard. I would too, because the circuit may be wrong. Now, what people need to know if you're not lawyers and don't know this principle of law is that it doesn't matter if the trial judge thinks the circuit court of appeals got it wrong. You can't overrule the court of appeals, the circuit. Only the circuit can overrule itself, or the Supremes. So even if the trial judge is convinced that the circuit got it wrong, if the issue is on all four squares, legally, factually, basically, also, then the trial judge has to do what the circuit says. And then you, the party, have to take it up on appeal and try to get the circuit to change its mind, which is somewhat different. I get frustrated often with trial judges where the law has changed since the circuit maybe ruled the last time because the Supremes have done something different. And you can see that the law is changing. Um, and sometimes the trial judges, I think, should be a little more assertive in saying this precedent is going to fall because there's a new understanding of what the law is. But in this case, those old decisions, and they're not that old, they're only a few years old, I think are solid, and Judge Chutkan, I don't think, can get around them, even if she wanted to, which she probably doesn't want to, right? She's not going to probably agree anyway that Judge Cannon got it right.
I agree. And then the next issue the Trump people want to have decided before they get to the mini trial on immunity is uh, are the Trump motions regarding Brady material, exculpatory evidence that Smith is sitting on, possibly, that would help Trump defend, and that would be just not only the merits of the case, but also immunity. I would think. What do you think?
Yes. Um, and so they kind of brushed that aside. They've got one paragraph in the government section or two here, one short section of two paragraphs saying, well, the defense has other motions. You, judge, have said you're going to do the immunity first. Um, the government notes it may promote judicial economy for the court to schedule briefing of all the other motions along with the immunity litigation. So they want her to take it all up at the same time.
That's so they get to file their massive uh, offer of proof, which means summary of their evidence of all of the things Trump did that was criminal, and that
Right,
makes out their case.
right. And they're
And
acting like that the factual underlying material is available for all of those motions when the defense's point on a half a dozen of them is that they need her to make rulings because it affects the discovery that they're getting, right, in the first place.
which goes back to my point. Smith proposes to file all of this basically without an opportunity to contest in advance or to object in advance, file it into the public record
Right,
and get gobs and gobs and gobs of press on it in the middle of an election season.
right. Interestingly, they did answer our question about this Rule 12, which is motions to dismiss. The government doesn't raise any problems with trying to say, well, Trump's too late, he's waived, he can't file a motion challenging Smith's appointment because the deadline for that has passed. So they seem to be in agreement that's not an issue. So that was one of the questions we had last week too. So they propose as the schedule with no dates. They say basically, we, the government, want to file this huge thing explaining why Trump is oh so guilty, 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 and not immune. And if the judge is going to let the defense file all these other motions, fine, they should have to file them on the same day. And then we'll respond to theirs and they'll respond to ours on the same day. And then everybody will get a chance to reply. So normally the way it works in motions practice is if you file the motion, the other side opposes, and then it's your motion, you get the last word, you get to reply to that motion. So the government's basically saying the defense can file all of their motions on the same day that we file this megaton bomb, and then we'll respond to theirs and they respond to ours. And then at the third set of papers will be whoever's motion it is gets the final word on that motion. But they don't propose any dates for any of that.
Now, Trump, the Trump side says, as to the immunity motion, they get to go first. They don't want to see a massive filing by the government. They want it's their defense. They should file the motion and explain to the court why immunity applies in this case.
Right.
And,
Which is
and
interesting. That's different than what we talked about last week, where we were
mm,
saying, how can the defense know exactly what evidence they're going to use and what you should object to without knowing what the government is going to say, what their witnesses are going to say, what exhibits they're going to use?
I've thought about that since last week, and I've turned around on it. Uh, uh, can I explain?
Sure, sure.
Uh, let's put the obstruction counts to the side. But as to the first count and the fourth count, one is conspiracy to defraud the United States, and the other is conspiracy to deprive someone of their rights, that is, their voting rights, by basically taking the position that the people who voted for President Biden don't count. So we're going to just throw their votes out, even though he won. That's what Trump was up to. Uh, if you step back a little bit, those are two statutes They're constitutional. They, under the Constitution, President Biden, as the head of the executive branch, has clear authority under the Constitution and under those laws to investigate and prosecute violations of those two laws. The violations they're talking about happened when Trump was president, which means at that time he had ultimate authority under the Constitution and those two laws to investigate and prosecute similar crimes. What crime is described by Mr. Smith? A conspiracy involving Trump's own lawyers, because those lawyers were telling Trump he won the election. We have evidence the election was stolen. So Trump at that time, when he was president, had it was within his uh,
Purview.
purview, it within his scope of his official duties to do just what Smith just did to him. Trump had the authority under the Constitution to investigate what the lawyers were telling him, uh, get his DOJ to and FBI to investigate, browbeat the states to investigate, report to him any fraud or irregularities or illegal votes. Uh, so it makes the case that kind of analysis sort of makes the case that this clearly is at a minimum presumptively immune. Whatever he did with those lawyers to shake the trees and look under the beds and under the rugs to try to find whether there was fraud and individual voters were having their votes eliminated because of alleged, you know, manipulation, uh, vote buying, stuffing ballot boxes illegally, uh, you know, flipping votes on machines. And so the kind of things that Trump is accused of doing, he uh, since he's dealing with the same laws that Smith is trying to enforce, he clearly was within his official duties.
Right. We're back to the tautology. I'm
Correct.
prosecuting you under a statute that, as the federal prosecutor, because I have the authority to do that, but you didn't have the authority to enforce that section when you were president. That doesn't make any sense.
It's wrong.
Right.
I mean, by definition, Smith has just proved uh, by bringing this case that Trump had authority. So how do you tee that up with the court? Do you let Smith put on his dog and pony show without any upfront rebuttal or contest by Trump when it's really you're talking about actions that Trump took when he was president? Uh, and in other words, were there genuine questions raised at that time by anybody? And I watched, as I said, I watched uh, Jeff Clark's lawyer, Harry McDougal,
Hmm.
in the in the bar, the DC bar effort to suspend his license. Uh, uh, McDougal put on a great case of showing there really was evidence that, at least in Georgia, he put on witness after witness. And John Eastman did the same thing out in California in his uh, bar license revocation hearing. He
Right.
put on a couple weeks worth of evidence
Yeah.
of that sort of thing. So I would imagine Trump's lawyers will do the same thing.
Or
And
try to. Right. Yeah.
sh- should they go first?
Right. Now they say Well, we haven't had the opportunity to cross-examine the special counsel's witnesses, call witnesses of our own, and that this makes the evidentiary record currently incomplete. They say, and incapable of supporting fact-based submissions, they mean to the court. So they say immediately proceeding to fact-based submissions, as the special counsel suggests, would violate the Supreme Court's directive to perform, and now they're quoting from the Supreme Court's case, an objective analysis of the content, form, and context of the acts to determine whether they're official or not, and therefore immune, which necessarily requires a fully developed record. And I'm looking at that thinking, okay, but normally in a criminal case, the way you do that is by holding a hearing, right? There's no depositions in criminal cases, right? And as Trump's can prepare all the witnesses of his own that he wants outside of the courtroom. So they're kind of saying to the judge, well, judge, we think that the full development of the record should be done between the parties, like it is in a civil case, and then both sides can make proper submissions to the court about it. That's not normally the way it would proceed in a criminal case.
It's I've never heard of it done that way, frankly, and I'm not sure the Trump side can really defend without cross examination.
You mean, well, are we talking about cross-examining the witnesses before they testify in front of Chutkin or after, while they're testifying in front of her? Clearly, they
While
would be entitled to.
Yeah, while they're testifying, or at the conclusion of their testimony, with the opportunity to object up front.
Right. What they seem to be saying, the defense lawyers, though, is that Smith shouldn't even be able to make a submission to the court until after the cross-examination has been had. And that would be very unusual in a criminal case.
I'm not sure how that works unless you have a live hearing in front of the judge.
Right, exactly. But they literally say proceeding to an evidentiary submission in this posture, meaning before Trump has had the ability to cross examine, would violate his Sixth Amendment principles, including the right to prevent defense witnesses and cross examine the government's witnesses. I read this to mean the Trump lawyers are trying to tell, she's not going to agree with this, by the way, you guys. They're trying to tell Judge Chutkin, you should let us depose these witnesses, right? You should let us develop the record between ourselves as lawyers before anybody makes any evidentiary submissions to the court. And, I know as sure as I'm sitting here that she's not going to let them do that. Don't you think, King?
I, there's no way. I don't think. Uh,
Right.
the only uh, no, I don't think so. I think you're going to have a live witness hearing in front of a judge to do what the Trump people are trying to accomplish.
Right. Now, maybe what they're trying to argue is that it's just premature for Smith to file an evidence-based submission, and that what should happen is that she should hold the hearings and then tell the parties to submit post-hearing like briefs that lay out what facts they're relying on in support of their argument. But again, this is like something you see in civil cases, but not really in criminal cases. So it's an interesting argument. They don't cite any case law. They're just citing directly. They're relying directly on the Sixth Amendment. But to my knowledge, the the Sixth Amendment case law is talking about the right to present witnesses and cross-examine witnesses at trial, or at a hearing in front of the court, but not outside of the courthouse. Although the criminal rules do have a rule for doing depositions in extreme circumstances, or extraordinary, I suppose I should say. So you can get permission to do depositions sometimes in a criminal case if, like, let's say a witness is terminally ill or is going to be leaving the country permanently or something like that. But it is not common in criminal cases. So, um, then they turn the issue around. They say the special counsel asserts it should file an opening evidentiary brief, but doesn't cite any authority or rule in support of this procedure. Basically, they're making the point Ship was making, which is they've already filed their indictment. Right now, you're gonna let them file another thing that says what their evidence is. Ship is back. Ship, I just sent you a request to join as a co-host. So you should be getting that here in a second. Um, when we talked about this last week, what I was suggesting is that as a defense lawyer, I would demand from the government to know, what their exhibits are, exactly which documents they want to use, which witnesses they intend to call, and get summaries of those witnesses. But I wasn't suggesting that that should be on the record, but rather that the government should have to disclose that information that way to the defense so that both sides can then prepare either to do a hearing or to put some things in front of the judge by stipulation or agreement and then have a hearing on contested issues.
An interesting point that you're thinking that through. Ordinarily, if you've got, remember, they have got attorney-client privilege based upon, or they pierce the attorney-client privilege based upon Howell's rulings in the grand jury. So that is subject to relitigation in the trial.
Right.
And they could argue that this should be done under seal to protect that privileged information.
I
Well,
was
not to
about to
mention the
Ship. I
fact
was
that,
about to raise the same issue.
yeah,
I think you have a serious attorney-client privilege issue here. Uh,
Remember, it's
cause,
five
'cause-
private attorneys who gave Trump advice in the
right,
same
advice. Right.
and
You've got that, you've got the classified information, and you've got the grand jury. So, I mean, this is normally why a lot of this stuff you work it out beforehand, right? And you're not doing this by written submission on the public record.
I actually think Smith's taking advantage to some degree of the Supreme Court basically punting the whole process back to Chutkan and say, as the trial judge, you figure it out, and then
Right.
we'll evaluate what you come up with. So Smith is trying to engineer what is, by far the best process for what he wants to accomplish. And when I say what he wants to accomplish, to my view, based upon what he wrote, he does not care at all about if there's a trial or when there's a trial.
Right. I agree with you. They've given up on that. So the defense says to the extent that the special counsel suggests that informing President Trump of its position on immunity issues in advance of any motions practice might be beneficial, Trump agrees with that, they say. They say President Trump sees the rationale for that in principle. However, such information may be provided by letter and should not take the form of affirmative briefs or other filings. Right? This would have been my position the whole time, which is, yeah, you have to tell us, but that doesn't mean that you put it on the public record until we're a little further down the road here.
while we're talking, what what is Smith going to say about Trump's uh, power as the chief executive to enforce the very laws Smith is enforcing?
Right. Their position seems to be that they're not going to disagree with that, but that's not what they think he did. They think he was acting in his capacity as a candidate when he did these things and not as the president, qua president.
Yeah, there's a very interesting. It's one sentence in the opinion that I took note of the first time I went through it. I think I mentioned it a couple of times, but I never went back and looked at the actual sentence again.
Ship
In
the
in the
opinion or the report?
No, in the opinion, in the Trump
Okay.
immunity opinion,
In the Supreme Court opinion. Okay.
and in large degree, I think Smith chose to ignore it. And this again is a signal to me that his motives here are ulterior. There's a reference in there that that Trump enjoys. I can't remember if they use the word heightened, but a heightened First Amendment right
Yeah.
because of his obligation to communicate with the public
Right.
in the role. And then the court later makes reference to something to the effect of that his comments are likely entitled to official act protection. I'm paraphrasing, even if the connection to his office is not obvious. Now, I mean, and that's essentially what the court says, is that there may be some acts that are official, even if the connection to the office is not obvious.
Right, because
Um,
they're viewing Trump, as I have always said, and people hate this, especially liberals, but you know, the president of the United States is a unique constitutional actor. And Smith just wants to ignore that fact. But the Supreme
right.
Court is not ignoring that fact.
Well, where he's particularly ignored it is he has left in all kinds of Trump pronouncements and tweets and comments
Right.
contrary to that admonition that that is a particularly ripe ground for challenging.
Right.
Um, because when Trump speaks, he is in office. He is speaking as POTUS. So how do flesh out comments that are strictly personal or private or as a citizen, and comments that are, infused with the authority of the office? And Smith just ignores it. Well, I mean, doesn't ignore it completely, because he does eliminate some, but he eliminates them in where he's speaking to government officials and stuff like that. But
Right.
anything he says under any other circumstances, Smith left
They've
it in.
they've left that in. Right. This was our
And and
discussion last
and
week.
they
He
call
didn't skinny it down to the bare bones. He tried to keep as much as he could.
right, and he called, this is the laugh out loud one. He called the January 6th at the Ellipse a campaign speech.
Yes.
What the fuck's he campaigning for?
Right. I think he capitalized campaign, if I'm not mistaken. Let me see if I can find that. Let's see. Whoops.
Maybe it was his first speech of the 2024 campaign.
Exactly. Let's see if I can find that. No, no, my search thing isn't working. Um, what do you guys make of this? The one of the defense positions is, well, we could litigate all of these immunity things, but the Supreme Court was pretty clear that Trump talking to Pence was presumptively immune. And they're basically saying there's no way Smith could get over that hurdle and overcome the presumption with the discussions with Pence as the vice president. And so that alone, if Smith wants to use that, that alone is cannot happen, and therefore, a ruling on that is going to rise or fall and have to be taken up on appeal. So, we've got a bunch of arguments, but there's no way Smith can win that argument, and that should be game over. What do you make of that argument?
Well, as I read the rationalization in the form of the language of the indictment, basically they're saying that that conversation was with the president of the Senate, not the vice president.
Right.
And so the conversation was about the duties and authorities of the president of the Senate. And in that conversation, Trump was speaking not as POTUS, because he has no official involvement in the electoral count process. So he could only be speaking to the president of the Senate as a private citizen or candidate.
Right. And so it's the same thing. It's like if you're a dual national, then Smith is saying that means I get to put it in. And I think the analysis should be no. If it's of dual character, that means it cannot come in because it has to be immune. But, the basic problem here is that Smith just doesn't want the law to be what the Supremes just said that it was vis a
Uh,
vis immunity.
see, I'm more cynical. I think Smith doesn't care. He just wants to leave as much of this stuff in the indictment as long as he can, until he's told he has to take it out.
Right. That could
I,
be. And he's just going to see how November goes. Right. Go
yeah,
ahead,
Yep.
King.
Yep.
I agree with Ship. I think he wants to fill up this record with as many bad things as he can come up with, uh, and make it public.
Well, the defense positing that, well, we could litigate that one issue and see how that goes because it's kind of, you know, the whole thing will rise and fall on that, if nothing else. But I don't think Judge Chutkin will take them up on that.
No, I think she is going to want to. I think, I mean, I actually think her inclination would be to have a mini trial. Let's start putting witnesses on the stand. And then she's going to make factual determinations with credibility evaluations and all the stuff that she would otherwise be doing, and filing her, findings of fact and conclusions of law or whatever you want to call it to create a record to go up. I don't think she is necessarily as focused on the election as she is just as focused on Donald Trump being strung up outside the courthouse when all is said and done.
What do you think, Ship, of this argument, King? This question King and I were debating
And
about.
I mean and I mean figuratively.
Yes, figuratively strung up, right? Um, so like what was it? Figurative evidence, the same thing.
Yeah.
What's your view on this question King and I were debating about? Well, um, let's see how to encapsulate that. King, you want to restate what you were saying
Yeah,
about?
sure. The the two statutes. Let's just put the obstruction case aside a minute. But the two statutes that go to the fundamental of whether there was or was not election fraud, and the two charges accusing Trump of engaging in a conspiracy to defraud the United States and a conspiracy to deprive voters of their rights. Uh, the facts underlying those two counts occurred while Trump was president, which means at that time it was within his official duties to enforce those two very same laws. And he had lawyers coming to him telling him, we've got evidence out there that show the laws were broken, that voters were deprived of rights, that somebody is defrauding the public in this election, and this needs to be investigated. And nobody should be certified president until that investigation is over and until a finding is made as to whether all these votes count and because they're legal. Uh, that was within clearly Trump's official duties to review all that, trigger investigations, browbeat state officials to do their own investigations. And when all that failed, he felt it was in his duty to buy some time so the legislatures could investigate. And all of that goes to presumptive immunity, doesn't it?
I think I'll say that I had until you kind of voiced that kind of mirror image, so to speak, of the allegations against Trump, and if when you consider that mirror image, you say, let's assume Trump was right, then is he not? Who is he then vindicating? He is vindicating the voters who had been said to have lost the election if he was in fact right. And why would that not have been a legitimate and authorized effort? It just turned out that as the clock struck midnight, they had not yet marshaled the facts necessary, and Trump was not obligated to accept, people telling him that he was wrong because there were other people telling him he was right. It was a matter still in dispute. The only time that dispute ended was when Congress ended the dispute. It was up. It was in dispute until the time Congress certified the vote.
I
Um,
mean, Bill Barr certainly thought that he was entitled to at least investigate those issues. Now Smith's sort of saying, well, the federal government has no role. That can't be.
oh yeah, that I think that's
That,
absurd.
that's that's obviously wrong because Smith, on behalf of the federal government, is bringing
He,
asserting violations of the same laws Trump would have been enforcing
Right.
had he been
yeah,
right.
yeah.
Yeah. Right. So, all right. And Chip, we were also debating this question of should Smith be able to make an evidentiary submission to the court at this point? The Trump lawyers seem to be arguing that until they've had a chance to cross examine witnesses and present their own witnesses, that it's premature for the government to make any evidentiary submission to the judge. Did you make of that they mean the parties should be deposing witnesses in advance of any hearing? Or did you make of that they think the court should hold a hearing and then the parties should submit like post hearing uh, proposals for what the correct facts are?
Well, again, you're going to have contradictory evidence from contradictory witnesses or from conflicting witnesses. You're going to have cross examination that is going to expose inconsistencies on the part of individual witnesses. I don't think that, I think the problem is nobody quite knows because the Supreme Court didn't say how it expected the process to unfold in trying to evaluate a claim of whether conduct was. And remember, it's a two-step process. It's official conduct, and then it's can the presumption of immunity be overcome
Right.
with respect to official conduct. So it's not one step, it's two steps. Is it official conduct? And what I wrote in my Substack is I think Smith's claim is going to be none of this is official conduct.
Oh,
We
clearly.
have
Yeah,
characterized
clearly.
it
Right.
all as private conduct. But even if the court finds it's official conduct, we are going to explain why we can overcome the presumption.
Right. That's what he
Um,
says they're going to do in their evidentiary submission. But the defense's point is
right.
it's too early to submit evidentiary submissions to the court. That shouldn't be
Well,
happening now. That should be happening later. What do you make of that argument?
I would agree with that because what I would argue if I was the defense is we need to settle on what the right procedural steps are before we start coloring inside the lines. Who goes first? Who has the burden? What is required to shift the burden? Chetka's going to have to make this up because
Yes,
it's never
she
been done
is. It's
before.
never been done before. But they're tying it to cross examination of witnesses, right? So, and I was
And I would argue, I would say it's analogous to saying that the government has the ability to simply dump all of its evidence in the form of a filing before it calls a witness in trial, and that's not acceptable. Although you could say a trial brief is similar to that.
right.
Um, but that's in effect what they want to do. They want to say here is and I think maybe the problem is they're giving it to the finder of fact, so to speak.
Right.
They're saying we are going to pollute you, Your Honor, with
Well,
everything that we think is true
right.
before you have an
Before you even
opportunity to
hear any
consider,
witnesses. Right. Let's use
or
a
you or the defense.
let's use a real world example to help us with this problem. So, when the government wants to use other crimes evidence, so we can help people understand, the way that works is they have to give notice to the defense that they want to use this other crimes evidence. What this means is if the government wants to use evidence that the person has committed similar crimes in the past or engaged in similar conduct in the past, the defense has a right to know that that's going to happen before the trial takes place. So the rules require the government to give notice of that, and then what happens, I did this in my last trial, is you file a motion as the defense with the judge saying the government should not be allowed to use this evidence for this purpose. They're basically trying to paint the client as a bad guy who does bad things, and there's no actual evidentiary use of this evidence. You file that motion, the government defends the motion, and then you reply, and then if necessary, the judge holds a hearing on that. But the first thing that happens is the government gives the defense notice of exactly what the evidence is. And then, depending upon which court you're in, which district you're in, that either goes to the defense as a letter or as a pleading. Now, Ship, where you practiced in California, was that a letter you sent the defense or a pleading you filed with the court of the other crimes evidence?
404B notice generally went in the form of a letter. Just here's what we're going to introduce. Here's the theory, and then it went to the court if the defense objected. The defense would file, a motion in limine to preclude the 404B evidence.
Right.
That's
The,
my experience too.
right. The rule says that it is a notice to the defense. Now, in some districts where I practiced, there was a local rule that said, okay, but you also have to file that with the court, which I always thought was stupid. But if that's what the rule says, that's what the rule says, right? Okay. So in if we're using this example of other crimes, why wouldn't this kind of work the same way? Ship, what do you think?
I mean, again, it's
It's the government that
there's
wants to
there's
use the evidence in both cases, right?
right now in 404B, there's an entitlement to use it so long as the government. Okay, so people understand the way 404B works is the government wants to use some prior evidence to establish like an MO, a pattern of conduct that suggests that this defendant engaged in the charged act, something he's done in his past that's introduced, as a modus operandi. That's the most common feature. Then the defendant comes in and says, "Well, Your Honor, that evidence that comes in for the jury, it's unfairly prejudicial. It's always prejudicial, but it's unfairly prejudicial because it simply leads them right to my doorstep when the government doesn't have any evidence bringing them to my doorstep. They're going to convict me just based upon this past event, not on the event I'm charged with. And then the judge has to balance it. So the
Well,
difference is the
first the
government's
judge has to
entitled by
find that it's offered for a proper purpose, right? Not
right,
just to show the defendant's a bad guy. And the reason
right,
Chip's calling it 404B is because that's the number of the rule that governs
yeah.
this kind
Rule
of evidence.
404, Section B.
Right.
Right.
Okay.
Now, the problem, where I think the distinction breaks down, but I don't know that it breaks down fatally, is the government's entitled by rule to use that. I don't know that the government's entitled by anything to use, although the Supreme Court has said they're entitled to overcome the presumption.
Right.
You know, but again, I think it has to go in two steps. I think the court has to first say what are the official acts, and let the parties hammer that out,
Right, I
and
agree. That's
then
why I'm positing this because it's sort of the two-step the first thing you have to do is identify the evidence that we're arguing about. Right? And
right.
so that can be done by public filing or it can be done by private communication to the defense. And so if you really strip it all back, really the argument here between these two parties is the government wants to dump that on the public record and the defense is saying, "No, you should send it to us privately and then we can fight about it later."
Yeah, again, I suspect that the judge is going to default to an open courtroom and the presumption that all filings are to be on the record and that there's nothing confidential about this information,
The defense is
except to the
saying,
extent that
yeah, to the extent that there's another rule that applies to make it private.
right.
But the defense is saying, well, the objection that the evidence is immune is ours, that's a defense objection. That's correct. But in order to raise an objection, you have to know the evidence that's being offered.
Two things: you need to know it, and you need an opportunity to object to it before it comes in.
Before it
So
gets in
you
front of the jury. Right.
right,
Yes.
and again, I'll go back to where we started. It is exceedingly unfair to dump the prosecution's whole case into the public record without giving the defense a chance to look at it first, object, raise objections, and potentially cross-examine witnesses. This may be devolve ultimately into a testimonial evidentiary hearing.
And that seems to be what they're saying, but I'm just not following that, I guess, because it, Judge Chutkin has to make the immunity decisions, right? She's not determining whether evidence is going to be put in front of a jury at this point. She's making a legal determination about whether the evidence that the government wants to use cannot be used because it's immune.
but she's going to have to make some factual findings, I think, because you have a two sides of the coin uh, issue of what Trump was up to. Was he electioneering, as Smith says, or was he performing acts within his official duties?
Right, that's the
And
determination he has to make. But what I understood you to say is that somehow the defense should be able to object before the government even tells the judge what the evidence is. So I'm not
it's
following that.
because as I read Smith's approach to this case, he has ignored from day one all of the things Trump did with the alleged fraudulent votes. Uh, None of that is in the indictment. It's never been mentioned in any of his pleadings. I suspect he never showed it to the grand jury.
Right.
And
Right. He
and
doesn't like that part of the evidence. He thinks
yeah,
that
but
that's
but
not valid. Yeah.
that's what was going on. You
Yeah,
read
but
the paper.
isn't that what the defense is going to introduce at the hearing though?
Yes, but
Okay, but
but
that doesn't mean that the prosecutors can't say, "Well, we want to introduce our evidence that helps us."
how is there? At what point is any of that relevant? If everything Trump was doing was investigating fraud.
Well, but the judge surely has to hear evidence in order to draw that conclusion, right?
That's my point. Yes,
Yeah.
both sides of the evidence, and with a right to cross-examination, a right of cross-examination, I would think.
Yes, at the hearing. But what these parties seem to be arguing about in this pleading is whether Smith gets to put on the public record the evidence that he wants to use first, or whether the defense should be given that information privately so that they can then file a motion objecting to the parts they object to. You see what I'm saying?
Yes, I think the defense is right, but the judge may go with Smith on this one,
Well,
as
yeah, if
Ship
you're,
says, put it all out in the public.
right, right. I'm not sure which way she'll go. I'm not sure what I would do if I were her, but my instinct just tells me that this is something that needs to be disclosed to the defense, but doesn't need to be on the public record yet. But I'm not sure what the defense means by they get to cross examine witnesses first before the hearing or at the hearing.
I
I
assume
think,
at the hearing, but because they haven't said otherwise.
yeah, I think they intend to, if they're going to put their what okay, so they're going to put their case in writing, and then they expect Trump to call witnesses to undermine their case, and then they will cross-examine those witnesses, not allowing their witnesses to be cross-examined. I mean, it's just, I mean, if I'm reading that right, again, it's just more evidence of the lack of good faith in this submission.
By the
You know,
prosecutors, you mean, right?
yeah.
You
What
had a
is the
lot of
possible?
pronouns in there. I wasn't sure which side you were talking
Yeah,
about.
but what is the possible justification under the opinion issued by the Supreme Court that says Trump has to put his witnesses on the stand to be cross-examined when it's his immunity to hold and the government to overcome the presumption?
Right. Well, I mean, there has to be a factual, scenario put in front of the judge from which she can make rulings, right? Um, but
Well, I think the easiest way to do that is she should order the indictment is what it is
right.
by page and line number. Put it on line paper by page and line number. Order the defense to identify allegations in the indictment that the defense believes are covered by immunity.
That would go so far, but not as far as probably necessary because you still don't know what evidence the government's going to use.
No, I
Right.
understand.
Yeah.
That's the first step.
Right.
That's just the first step. Then she would have to make an initial determination as to whether it is official or unofficial acts. And if testimony was necessary for her to make that determination, then you would have the testimony. But it is the defendant, it is the government's obligation to establish the official act. So I think Smith has to go first. Smith can only prosecute him for official acts, or Smith can only prosecute him. Well, no, I take it back. Smith can only prosecute him for private acts, and he can only prosecute him for official acts about which he can overcome the presumption.
Right.
So now Smith will say there's no official acts. And Trump will say, no, oh no, the following are official acts. And then that's the first sorting point. And if testimony is necessary, I see this is where it can never happen just by filings. I think that's kind of what Smith has in mind. Just we're just each side is going to spit their filings, and the court can draw its own conclusions. And I don't think that's anything close to enough. Not the kind of factual record that the Supreme Court's talking about.
That they were contemplating when they sent it back. I agree with you.
Right.
What I'm stuck on is the sort of step one, right? How do we even know what evidence we're talking about if the prosecutor doesn't identify what it is? Because the defense doesn't have the ability to know everything that the government intends to use at trial, like, for instance, what the testimony of their witnesses is going to be.
Well, that's why I think the obligation is on Smith to put forward as much as he is willing to put forward at this point to establish that it is either a private act or it is a public, an official act for which the presumption can be overcome.
Okay, but isn't that what he's proposing to do?
No, because I think the defense has to first. There may be official conduct that they don't care about, and they're not going to assert immunity over. Until you give the defense the opportunity to sort of parse through every allegation in the 35 pages, you don't know what is in dispute. Smith is going to say it's all private. So the disputes are only going to be about what Trump says is official.
Okay, so let's get granular. Whose motion is this, in your view, Ship? Motion for the government to use evidence, to have evidence admitted, or
No,
the
no,
defense
no.
motion to
I
have
think it is the
evidence
defense motion.
excluded?
I think it's the defense motion to assert immunity. I think it's the defense motion to assert immunity over particular allegations of the indictment, and therefore exclude all evidence regarding those allegations.
Right.
I,
And any
I,
other evidence that is also immune that might go to allegations that on their face aren't, right? Because there's two problems there. Okay, and so what you're saying is you think it's a defense motion, but then when you're doing the legal analysis, the government has the burden.
yeah. What
Correct.
remember, the defense has already filed this motion. That's what, and
Right.
the denial of that motion is what got to the Supreme Court. But I think that motion needs to be amended or supplemented after the Supreme Court's opinion, because the case is still around, and the defense did not win 100% of its motion. So
Right.
so so
So if you go back to the description of the three buckets, you have three buckets of allegations. You have core constitutional conduct is bucket one. Well, Smith's going to claim he took all that out. He took all the DOJ control stuff out. So all the core bucket one stuff is gone. Now, Trump might disagree, but at least Smith's going to say, I took all that out. Then the second bucket is official acts. And Smith's going to say, there are no more official acts. We took all the official acts out. Everything we've left in as private. Trump's going to disagree and say, no, the following things are official acts. And then the third thing is going to be private. And Smith's going to say it's all private. And Trump's going to say, oh, no, just a few things are private, but most of it is official acts. So I think to isolate what's in bucket two is the first step. That's all you're going to be fighting about.
which requires an amended uh, motion.
Exactly, because you got a new indictment.
Yeah.
So you got, and I think now, based on what the Supreme Court said, you have to go allegation by allegation. What does the defense object to on the basis that it's covered by immunity?
Yeah, okay, but the Supremes have also said that in support of proper allegations, they can't use evidence that's immune either. So also the defense needs to say, and on top of all of our objections to these allegations, we object to the government using any evidence that is immune also, if there's any allegation left over that is not immune. You see what I'm saying?
Correct.
Yeah.
Yeah.
So what I know
So I
is
don't
when
think
you
they're
get
gonna.
in
I don't
front
think
of a
they're gonna.
judge, the judge is going to say, what evidence are we talking about? Mr. Prosecutor, uh, allegation page, whatever, paragraph, whatever of the indictment, what evidence are you going to use for that? Right? Because the judge can't just rule in a vacuum.
Right, but that's only after you've limited. That's only after you've gotten to the official acts subject to immunity. Then okay, and what evidence does that implicate? We
Yeah,
know the official acts. We know you can't prove up those allegations. They now have to be removed. And see, that's going to be the next thing: is that
Mm-hmm.
are you gonna is he gonna be forced to amend the indictment so that it
Right.
only reads? And how well does it hang together when we
Right.
take
Or
this
will
to
the
that?
judge just strike stuff out and say, well, I'm going to let you keep these paragraphs, but not these other ones?
Right. And then, but then, is it? Are you doing? Is that doing fatal damage to
Their
the
theory of the case or whatever. Right.
Right?
Yeah. So it sounds like what we're really coming down to is we think Smith's going to have to do what he's proposing to do, but he's trying to get there too fast.
Yeah, he
yeah.
wants to front load it. He wants to front load what he's going to have to do.
And that process it doesn't work if you have not identified the private acts and
Right.
separated them from the official acts. Because he without that taking place first, he can't tell the judge what evidence he wants to use.
Right. Exactly. And this brings me back to your point from last week, King, which is basically by not going skinny, by leaving all of this shit in the indictment, Smith has just made a huge clusterfuck out of this because you start running into these circular arguments. He's going to say it's private conduct. The defense is going to say it's public. The judge is going to be like, well, what's your evidence that it's private? What's your evidence that it's public? What's the other evidence that's available from the defense, right? To undermine Smith's assertion that it's public. And it's just going to go round and round and round.
Now,
See, that's why I think the approach has to be, you know, list them on a page and tackle them one at a time,
Right.
and then and just knock them out one after another, and then make some kind of findings about the evidence that is disqualified and the evidence that is still available.
Right. Because her order has to say what is in and what's out
Correct.
immunity wise. Right.
Correct. Not just the allegation, but also the evidence behind the allegation.
Right. Or evidence in support of any allegation that she deems to be private.
now this case has something unique. If she has in mind an evidentiary hearing, particularly one that's semi-lengthy.
Which is going to be, we can't even talk about the basics of it ourselves in like less than 2 hours.
And but how do you do that with Trump the candidate?
Right.
Is he going to be tied up for weeks sitting in court?
Now that's overt election interference.
By the court. Right. To
Yes.
tie him to a chair. I agree.
Correct.
Well, she could waive his presence, right? For the hearing. That's not
So
often
she's
done in
put.
criminal
So
cases, but
yeah,
she can.
but I think that would be dicey because he could say, "I am, a federally recognized candidate for the election of the office of president in 50 states on November 5th, and at the same time, I have a right to be present for every hearing."
Right. And defend myself. Right. Yeah. And assist my counsel.
Right. So it is a violation of due process for you to put me to that choice.
Right. Okay. So let's get down to some more brass tacks. What do we think Judge Chutkin is going to do with this mess of a status report that they sent her?
That's why I'm going to be there on Thursday.
Tell us what she does. Yeah. So folks know the defense is part of the pleading. They give a table with specific motions that they want to file by specific dates. and they lay it out in an order that's somewhat logical. Rule on the Brady stuff toward the front, rule on whether Smith is properly appointed toward the front, rule on the scope of the prosecution's team toward the front, so that because that implicates Brady production, and then they roll into the more substantive motions after that. And they had proposed let me get these dates up here. They had proposed um, all the way
All the
up
way.
to spring through fall of 2025 for additional proceedings if necessary.
Yeah, without a trial date even
Right.
hinted at.
No trial date.
Now,
Yeah.
let's talk just for a minute. And actually, I've only got a couple more minutes, and I'm flying tomorrow, so I got some stuff
So
I
you
just
got
want
to
to do
go.
tonight.
Okay.
Yeah. So, but what they are proposing is extraordinarily atypical. Now, this is an
Yes.
extraordinarily atypical case, but in just so everybody knows, in a general criminal case, the court will set one date and say all your motions have to be filed by that date, and
Right.
then a
The other
certain
side has
amount of
2 weeks
weeks
to
later,
reply,
there's
and right.
exactly. So you do them all. You work on them over a period of weeks and months. You do them all, have them all ready to go by the date you file them. What Trump's team's proposing is we're going to do this little motion by this date, and then once it's all resolved, we'll file our next one by a couple of weeks later, and then once that was resolved, we'll jump to the third set of motions. It's
Right.
like
They
I
don't
don't
even
think
want to
that's
have
going to
to
fly.
move to dismiss on the immunity grounds until December 13th.
Yeah, they want to go kind of station to station, one issue at a time, all with separate briefing. That just, I don't think that's going to go. Now, she might break it up into two or three groups that are, typical Rule 11 motions. Or Rule 11?
12.
Rule 12
Yeah.
motions, typical Rule 12 motions that are common in many cases. But she might have the immunity stuff all set aside because that's going to have to go early before you get to other substantive issues. She might throw in with the immunity stuff at the same time the Jack Smith DQ motion, but she's going to say, look, I am bound by circuit authority on
Yeah.
that question.
We talked about
I
that
can't
while you were
that
off. Yeah.
yeah,
She
yeah,
can't really
that
do
motion
anything
is
with that.
going nowhere.
Right.
That motion is going nowhere. Only the Supreme Court can solve that problem. So I can tell you right now how that's going to come out, but I understand you need to file it to make record and take it up on appeal or whatever. But that's not going to be much time or effort expended on that. Um,
But
and
the
then
Brady stuff, she has to decide those because that
that's
implicates discovery.
now remind me, was the scope of the prosecution team that was raised in Florida? That was
No,
not
that's
raised
one of
in
the ones
D.C.
here too. Yeah. They want her to rule on that. And they say because, how can we even get all the discovery to make objections to? You
Oh,
haven't even
absolutely.
said who's on the team yet.
The scope of the team expands the obligation to collect documents and produce discovery.
Right.
And so I can't. Well, I guess yeah, that's right because they were talking about no. It was in Florida where they were talking about whether the archivist was part of the
Right.
prosecution
Yeah.
team and somebody else. So dramatically expanding the Secret Service part of the prosecution team. None of that really exists in the DC case. This prosecution team in the DC case can come down to the FBI and, to the extent January 6th is an issue, the Capitol Police. Um, I don't know how much broader it's really going to get.
Let's see. I'm looking for what they said about that in their pleading. They want time to deal with Fisher separately too.
I just had an 11th hour motion to continue my sentencing for this week, filed last Friday, because the government still can't come up with a coherent sentencing, a coherent adjustment to the guideline calculation to take into consideration Fisher.
Right. Yeah. Yeah. So you're right. They're not talking about the scope of the team here. What they do say is that, okay, the government is saying it complied with Brady, but the Supreme Court hadn't ruled on the immunity yet. And so any review that they did for Brady, they didn't take that into account.
Yeah, that's right. I remember reading that, and that is an interesting argument. Now they have to. Brady is going to include within the scope of Brady evidence of immunity,
Right. Yeah.
because that's goes to the innocence of the defendant, so to speak.
Right. Right. Or mitigation.
I don't know. That's an interesting question. Does immune conduct equate to innocent conduct?
I'd use the word exculpatory. It 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 tends to exculpate him from criminal liability, right?
I wouldn't say exculpate, no, but in a looser sense, yes. They,
But Brady has been kind of narrowed down
yes,
to evidence that focus on actual
right,
innocence.
exactly. Yeah. And so, yeah, it helps you win the case, but that's not the test for Brady. They do say at the end of this page, for similar reasons, if this case is not dismissed as it should be, that the court must then resolve the pending motion for an order regarding the scope of the team, because they'll have to search in those for those team members access to immunity documents too.
Well, there's an interesting. I guess it's not the same as what do we call it when the prosecution is exposed to attorney-client information.
Taint
Garrity.
team. No, not Gary.
Gar-
No.
Okay, but that would be an interesting argument
Yeah.
if the prosecution shouldn't have been exposed to evidence of immune conduct.
Right. Yeah.
Let's hire another special counsel and start over again
Start over again.
with a taint team.
Yeah, the taint team. Yeah. So, all right. Well, I'll be fascinated to see what Judge Chutkin does, because, I have a lot of issues with how she's handled this case, but I don't think it's super clear the procedure that the Supremes
Oh,
thought should be
it's not at
happening
all.
here. So she's going to have to, create this, and she's going to have to
Yeah,
look
but
to
that
some other areas of the law to figure out, okay, well, we
but
do.
that kind of goes to the pointed comment that Roberts made in the opinion, which
Hmm.
is we are a court of final review, not
Right.
a court of first
Right, you
review.
guys should have done this
And we
before.
and we find ourselves in this position because the district court and the circuit court abdicated their responsibility, so
Right.
to speak. He didn't use that phrase, but
No, but he was clearly
basically,
pissed about that.
all right.
Yeah, and he should have been. So, I suspect and predict that she will look to some other analogous, determination that she has to make in other cases to figure out what the procedure should be. Whether she'll be right or wrong, I guess we'll find out on Thursday.
All right, I have to drop off.
All right, guys.
So
Sorry for the delay. I'll have to set a notice for myself next time, I guess. It's never happened to me before that I lost track of the time. So, but thanks for joining. King, have you got any final words? You got any Monty Python quotes
No,
for tonight?
um, I'm just interested if to see if Judge Chutkin got the subtle hint, wink, wink, nudge,
Yes.
nudge, nudge, say no
Right.
more
Right.
message.
Yeah. Did she receive that communication or not? We'll find out on Thursday. All right, you guys, and then we'll probably do another one of these, either Thursday or maybe Friday. I'll talk to the guys and see what the schedule looks like, especially Ship, since he's traveling. So, good night, all. We'll talk again soon.
Good night.